Item number 43. Now, it is fixed for hearing at 2 p.m., my lord. 2 p.m. Your lordship has a different time.
It will be placed on any date when no 2 p.m. matter has been fixed.
That matter, my lord, only I rely on 2 or 3.
It would be placed. তন্ময় বাবু যেদিন ফাঁকা থাকে সেদিন দিয়ে দেবে আজকের গুলো বুঝলি হ্যাঁ 22nd August 22nd August.
It will be only for 2 minutes required, my lord.
Okay, 2 minutes.
Next week, any day, my lord. Next week, any day, my lord.
Next week 2 p.m.
At 2 p.m. all, my lord. 1 p.m. it will be finished, my lord. I only rely 2 or 3 rules, my lord.
What your higher scale of pay?
My lord, my lord. So that matter, my lord, after 2017, I acquired the qualification.
Okay. Yeah.
I, my lord.
আচ্ছা একটা ফাঁকা ডেট দেখে দিয়ে দেবেন ওনার হায়ার স্কেল অফ পেটা শুধু 29th দিয়ে দেবেন ওকে টাইম দিতে হবে না আপনি ইয়েতে দিয়ে দেবেন একটা ফিক্স ম্যাটার বলে দিয়ে দেবেন
My lord.
61 হ্যাঁ ওকে এইটা একদিন দিয়ে দেবেন তো হ্যাঁ ওনার একদিন দিয়ে দেবেন হ্যাঁ Yes, 61 onar দিয়ে দেবেন Yes, call the
Yes, Your Lordship, may I be permitted to mention one item number 23 in today's list? Your Lordship, there is a difficulty on behalf of my senior. He won't be able to appear before Your Lordship today.
Who is your other side?
I am for the petitioner, Your Lordship, and others.
Okay, not today.
No, Your Lordship, can it be fixed on next Friday? Because
You are the double pair
Your Lordship, my senior.
Adjournment and you are seeking fixation of this
Your
matter
Lordship,
according to
senior-
your choice. Okay, it would be listed. Or keep watch on the list. Okay.
Much obliged, Your Lordship.
Okay. Next, call the list. Call the list. List. They have already joined.
Fourth player matter, item number 1.
My lord, I am for the petitioner, my lord.
Yes.
My lord, here the order is at page 10, my lord. Relevant page is page 13. Relevant page is page 14, my lord. Para 4.
Yes.
Para 4, my lord. Having had the learned advocate on record and upon perusal of the materials placed before me, I am of the view that to avoid any future disputes, it would be appropriate for the Tahsildar to conduct a physical field inspection before issuing the sketch map. Therefore, in view of the above, the writ petition is disposed of, directing the respondent number 2 to consider the petitioner's pair for the issuance of the sketch map in respect of the subject land. After the completion of the field inspection, the entire process shall be completed within 2 months. This order was passed, my lord, on 31st January 2025, my lord. Thereafter, I have communicated the same. That is the next page, my lord. Annexure P2. It was communicated on 7th of February 2025, my lord. Till now, they have not done anything, my lord. Nor the field inspection was done, nor they have given the sketch map, my lord.
Well, Miss Das.
My lord, I am for the contemners, my lord.
Yes.
I bow down, my lord. What to say, my lord? My lord, may kindly allow some time, my lord, so that we can comply your lordship's order, my lord.
My lord, we are compelled to file this contempt application after.
Have you received the
contempt
contempt application?
No, my lord. No, my lord. We have not received the contempt
So
application.
received it.
My lord.
Okay, ask.
My lord, may kindly give a direction to the petitioner to serve the copy to the.
Yes, I am giving answer. Miss Minil, an advocate representing the petitioner, submits that the order, violation of which is subject matter of the present contempt application, was communicated to the alleged contemptor. However, despite receipt of such order, no steps has been taken to comply with the same. Stop. Ms. Das has entered appearance on behalf of the alleged contemptor. He submits that some additional time is required to complete the entire process of issuance of the sketch map upon completion of field inspection. Stop. In view thereof, a petitioner is directed to serve a copy of this application to Mrs. Das, leaves the matter for further consideration. 8 weeks hence,
My lord,
2 months.
my lord.
My lord, already 2 months time was granted. It was expired on April, my lord. Now we are in July. Now again they want 2 months time, my lord. Because 2 months time was
Okay, okay, 6 weeks.
My lord, 8 weeks, my lord. 8
my lord,
weeks.
8 weeks was granted in the writ petition. Now we are in
Miss
contempt.
Das,
my
Miss
lord.
Das,
My lord, my lord.
Contempt
you,
petition, my lord.
My lord, we will do it, my lord. My lord's order, we
yes, yes, yes.
apply it, my
They
lord.
have not complied, my lord. They were waiting for another 6 months.
6 weeks.
My lord,
Miss
no, my
Mini-
lord. It was passed in the month of
My lord.
January, my lord. Now we are in
Oblige,
Okay,
my lord.
okay,
6 months I have filed it, my lord.
I can understood your agony. Please wait and for another 6 weeks.
My lord,
Okay, Miss Das, do it.
my lord, we'll do it, my lord. We'll
Yes.
comply. My lord. Oblige.
Yes.
Fourth player, matter 2.
Yes.
My lord, here I am for the petitioner, my lord.
Uh,
My lord, here also the same thing, my lord. Here some improvement they have done, my lord. They have passed the order also. I have annexed. It's at page P5, my lord. The original order is at page 14, my lord.
They have passed order.
Yes,
Passed order, but they have not complied fully. The thing is that, my lord, there was a direction. Kindly see page 14, my lord. The order was to implement the order of 7th.
Page 14.
Page 14, my lord. Has
Page
passed.
14 is this court order.
My lord, my lord.
And the operative
My lord,
part.
My lord,
Operative part.
page 14, implementation of the order 7/3/2023. So, my lord, the operative part has page 16, my lord, para 12. Accordingly, this petition is disposed of directing the Tahsildar consent to take all necessary follow-up actions to implement the order dated 7/3/2023. 7/3/2023, wherein it was stated that, my lord, direction was issued to the private respondent to vacate the unauthorized occupation. My lord, after physical inspection, they have to complete the entire process. Here, my lord, physical inspection has been done and the order has been passed. It's at page 22, my lord. Order has been passed. It was passed on 12th of April 2025. Kindly be seen, my lord. Page 22. But, my lord, it was not, unauthorized occupation was not, it has to be given to me. That was, order is there in the paper. Physically not handed over, my lord. Land has not handed over. They have come to a conclusion that 22 square meter is encroached by the private respondent. But it has to be in the paper. They have made the order in the month of April 2025. But till now, my lord, they have not complied fully. It has to be.
Yes.
This order has been passed. It's in the paper, my lord.
The,
But
phys-
it has to be
the physical inspection was done, my lord.
And
That was
final order was passed. Final order
was
was
conducted in presence of both the parties, my lord. Even the private respondent whose name was struck down at the request of Mr. Kabir. At that time, he said ki the name of Mr. Saji was there, whereas
that is already over. Now the final order has been
was
passed.
there.
Okay, Miss Mini, allow me, Miss Das, to conclude his submission
If my lord
and
sees
allow the court to know what has happened.
My lord, my lord.
Yes,
my lord,
yes, Miss Das, in
My lord,
compliance
we
with
have
this
done
order.
my lord, we have done the field inspection, my lord, and we found that the adjacent plot holder, Mr. Saji, has encroached some portion of land, my lord.
Yes.
So, my lord, we have passed this eviction order dated 7/3/2023. Whereas in this writ application, my lord, Mr. Saji was not the party.
Now, whether the order dated 7th March 2023 has been implemented or not.
My lord, it was in the paper. Page 22, my lord. Page 22.
We have
Page
passed
22.
the order, but it has not been, the eviction was not been done, my lord, as yet.
Huh?
Eviction, was not done, my lord. We have to evict that encroacher, my lord, who has encroached that particular land.
When it would be done?
My lord, I have to take instruction because today Tehsildar is not in station, my lord. So I could not get the
The order was passed 12/4/2025, my lord. Now we are in July, my lord. Past 3 months. they
My
have
lord, we have to know whether this the adjacent plot holder has filed any appeal to that order passed on 7/3/2023. Since
We
7/3
are giving opportunity. That's it.
appealable order, Yon.
Yeah.
It's an appealable order as per the regulation, my lord. The 7th March.
Appealable order, but at the time of hearing of the writ
Yes,
petition,
my lord. At that time, he because since it was the order was passed in the name of his wife. His wife's name is also there. The order is to that effect that his wife has started construction. His wife's name is also there. And at the time of giving the notice, Mr. Saji's name was there. It is that both names were there. So, my lord, I have to see whether they have filed any appeal.
Miss Das,
After my
let
lord's
us,
order, this order was passed, my lord. After
Let
my
us-
lord's order, inspection was done. This
okay,
order.
okay, Miss Mini, let us arrange the sequence of events. At the time of hearing of this writ petition, both of you stated that the
No.
one Mr. Saji encroach upon certain portion of land. And Tahsildar passed an order dated 7th March 2023 for eviction of such unlawful encroacher. Now, at the time of hearing of this petition, you stated that unless and physical inspection is conducted, he cannot be evicted, and the order dated 7th March 2023 cannot be implemented. It is your Tahsildar's order.
My lord, my lord, my lord. It is
And
my order.
therefore, the writ petition was disposed of that you implement your own order
My lord.
because of the fact, although the order is appellable, but no appeal has been preferred.
My lord. At that time, no appeal was preferred.
Okay. And you, since you submitted that a physical inspection is required to implement the order effectively, so court directed, yes, before implementation, you conduct an inspection.
My lord.
That was done, my lord.
So you have conducted inspection.
Conducted
Now,
my lord.
Now, unless there is any stay of the order from the any appeal court staying the operation of the order dated 7th March,
My lord.
you cannot say, you cannot stay your hands also.
My lord.
You have to implement that order. It is
My
your
lord.
own order.
My lord. My lord.
Now
It is not the order of the court. It is your own order. Your own Tahsildar passed that order.
My lord. I do agree, my lord.
Now after
So
inspection,
you do it.
My lord.
I am keeping it on the same date for
My lord. After 6.
so that you can appear. Today you take
But
the
the
copy of
contempt
the application.
Yes, contempt application can be handed over to
Yes.
me.
Yes.
my lord,
The
I
present
ask-
contempt application has been preferred, alleging willful violation of the order dated.
January 31st.
Okay, I just missed. খুঁজে পাচ্ছি না।
January 31st, my lord.
page, my lord.
January?
11. Page 11, my lord.
Yes. Order dated
30, my lord.
February
February 5th.
5th, February 2020.
5th February 2025. Stop. Miss Mini, learned advocate, repenting the petitioner submits that the order was duly communicated to the alleged contemptor. However, despite receipt of the copy of the order, no steps has been taken to
Steps
comply.
have been taken, my lord. Yes, steps have been taken, my lord.
Okay. Okay, I shall record. It is Miss Mini's submission. Acha. No
Let's
step
have annexed, my lord.
in compliance with the order. Stop. Acha. Miss Das entered appearance on behalf of the alleged contemptors. He submits that in compliance with the said order, inspection was held. However, the entire process
Has not been completed.
Order has been passed, my lord. It's a
Yes, to
23, my
implement
lord.
the order dated 7th March 2023 could not be completed. You requires additional time.
My lord. My
Acha,
lord.
submit
Because, my lord, there is a case of
Sub-
eviction, my lord. We have to evict
Acha,
and
sub,
closure, my lord.
Acha, additional time is required to comply with the said order. Stop. In view thereof, petitioner is directed, petitioner or petitioners? Petitioners are
Petitioners, my lord.
directed to serve a copy of this contempt application to Ms. Das. Stop. And leaves the matter for further consideration. 6 weeks since. Stopped. It is clarified that pendency of this contempt application would not prevent the petitioner from taking steps in compliance with the said order. দুটোতেই এটা করে দেবে ঠিক আছে লাস্ট
Oblige, my lord.
ইয়েস নেক্সট ওকে এই যে লাস্টেরটা দিয়ে না পেন্ডেন্সি অফ দিস কন্টেম্প্ট অ্যাপ্লিকেশন ওটা আগেরটা করে ইয়েস
Daily list, item number 1.
Item number 1, my lord, I for the petitioner, my lord. My lord, last Friday, your lordship directed me to serve notice upon the learned advocate, my lord. My clerk tried to, but failed, my lord. My lord, may I come back after serving the copy of the
ডাইরেক্টলি টু দ্য
learned, copies of
রেসপন্ডেন্ট
the learned GP, my lord? Learned GP, and come back. May I serve the copy of the writ petition,
who is the respondent? Let me see.
video and district magistrate, all are the, my lord, district respondents, my lord.
ওকে আচ্ছা আসুন Mr. Hogg, learned advocate, representing the petitioner, submits that despite best report
Yes,
They have also filed their response to that said notice.
yes.
Now the next you give hearing and take decision in accordance with the law. I think at this stage it would be
Proper.
proper at this stage.
One more aspect, my lord.
They already passed that order, my lord. A hearing will be done, then,
Have you finished?
no, no,
You are the promoter. You are the promoter.
Yes, my lord. I took a sanction from municipality to construct a property. Sanction was given at least 5 years back. I have constructed the building. But now the notice is being served that it is within 200 meters.
That within 200 meters there is an heritage building.
yes, they have to take
Of the
permission.
heritage building.
And hence, before undertaking any construction work, you should have obtained permission from them.
Absolutely.
Yes,
Absolutely.
It is their stand.
Fair case.
Uh,
And this is a
The
notification.
question is, I'm sorry, my lord. The question is whether it is within that prohibited area. My lord, your lordship will kindly take one paragraph, my lord. Page 54 of this application.
of the application or read petition.
Of this writ petition.
Read petition, yes.
54, my lord.
54.
54.
54 here, read petition page, up to paragraph 50.
My lord, your lordship kindly come to page 54, my lord.
Of page 54, yes.
The last paragraph
Yes.
of their affidavit in the earlier application.
Hmm.
As per section 20B of the Ancient Monument and Archaeological Sites and Remains Act 1958, the proposed land of the construction work within the regulated area of the centrally protected foreign Hastings House in the northern side at an approximately 180 meters. My lord, this is the first statement, 180 meters. It should be more than 200 meters. Now, my lord, if your lordship comes to page 102,
It is their affidavit.
it is their affidavit. Earlier
In the earlier rate.
Okay.
Page 102, paragraph 2. This is their letter.
Yes.
Your construction, has your lordship got it, my lord?
You have carried out, paragraph 2, you have carried out a construction on such and such.
199. Your construction from the protected limit of the aforesaid monument is 189.52. Therefore, from 180, it becomes 189. That time it may be 300. Therefore, my lord, what is the position? Am I within the period or outside the limits?
Okay. I mean, ask.
My lord, one more.
It is not 200. no?
Yes.
If your lordship comes to page 71 of this petition. Down.
Yes.
Schedule.
Yes.
It's a gazette notification.
Hmm.
Revenue plot numbers to be included under protection.
Hmm.
My lord, 598, 589, 555, 591.
Hmm.
None of these are dogs are on which the construction has been made. Our plot number is 511.
It is a gazette issued
Gazette.
by the archaeological notification. Acha, okay.
Yes, my lord.
Starting from 65.
Acha. This gazette schedule appended a schedule mentioning the land
Yes, my lord.
which should be treated as a regulatory area, which will fall within the regulatory area.
Yes, my lord.
Okay.
So these dogs are not in my possession.
Acha. In questioning the justifiability the order of this court.
Yes.
Shall I set aside the same? Sitting in appeal over that court.
No.
And upon receipt of such notice, you submitted a reply.
Yes.
They are to. Now they are to act accordingly or take next steps
For hearing. my lord.
upon receipt of reply from you. That part has not been done. And hence court directed you complete that portion.
And until that is done, no steps.
And until that is done, both parties are actually asked to maintain status. Actually, although status quo has not, the word has not been used, but meaning of that order is that. Okay?
Yes, my lord.
Yes.
I'm grateful to you, Lord.
Yes.
Item number 3.
My lord, for the DVC respondent, my lord, in this matter.
Yes.
Respondent, my lord.
So this is a restoration application, my lord. My lord, while dismissing my can 3
Within time. Within
My
time.
lord, my lord, three times.
other things, my lord,
Huh?
that has to be.
3 times restored.
Okay.
My lord, Lordship, kindly see the order of 15th January 2024, my lord. There is a wrong observation. My lord, may I read?
Okay, ultimately dismissed for default.
My lord.
There is an observation, my lord. My lord, I am reading, my lord. Record reveals that an application being can number 3 of 2022 in connection with WPA such and such is pending, which the applicant has prayed for recalling of the order of the Honorable Coordinate Bench dated such and such and a further direction to place the writ petition number in original file and the number. It appears that while order dated 25th February 2022, the Honorable Coordinate Bench has dismissed the writ petition. This is wrong, my lord. On that date, can application 2 was dismissed. Lordship, kindly take up the order 25th February 2022.
So according to you, writ petition has not been dismissed and can 2 has been dismissed.
Lordship.
Can 2 was, why can 2 was filed?
My lord, initially there was an order, my lord, it's a tender matter. There was a penalty clause in the petition, in the tender agreement that after certain period, I will not do any defect work, my lord. But a notice has been given after the, my lord, penalty.
Oh, I am asking you the fact of the writ code.
Interim order was passed to take back my vehicle, my lord. But whenever I went there to take back my vehicle, I saw, my lord.
You have one by one.
Lordship.
You have filed this application can 4.
Lordship.
Can 4 2024.
Lordship.
Why? To restore the can application 3 of 2022.
Lordship.
Huh?
Lordship.
Acha. Why can 3 was filed?
My lord,
Because of the fact your can 2 of, I don't know, can 2 of
this was
2021, according to you, dismissed for default.
Lordship.
Shanichani. What can 2 did, can 2,
My lord,
you
for
filed
interim order.
since your writ petition was dismissed for default.
No, my lord.
Oh.
In the writ petition, I obtained an interim order that my vehicle, which was kept by them, will be taken back by me. But
So according to you, writ petition has not been dismissed for default.
Lordship.
What dismissed for default? Can 2 and can 3.
Lordship. I'm deeply obliged.
Okay. So if I allow your application, can 3 will be restored.
Lordship. Can
Then what is can 3? It is
Can
within.
3 is the dismissal order of Can 2 for restoration of Can 2. My lord, I want to press Can 2 only, my lord, because that is for interim order.
So Mr. Chatterjee, I am allowing.
I leave it to your lordship, my lord. Kindly,
Okay.
kindly consider the conduct of the petitioner, my lord, 2017.
Yes. Your conduct will be taken care of.
Lordship.
Will be kept in mind.
Lordship.
It is the conduct.
And
How-
I have not been.
How vigilant litigant you are.
I have informed today morning, my lord, for appearing. No,
My
not notice is served
will
upon
be
me.
kept for hearing, my lord, because only one
Why?
point
After 6 months.
after any date may be given, my lord.
No, court is not for that litigant. Court is only for the litigant who is vigilant. It is not my words, it is the words of the Supreme Court. Many matters every day coming. Okay. So allow the court to deal with their case, who are the vigilant.
Then, my lord, can 2 maybe, my lord, listed Friday, my lord, next Friday. Can 2,
As
my-
can 4 of 2024. Stop. আচ্ছা, having heard the learned advocate, আপনি মিস্টার চ্যাটার্জি through PC করে দেবেন. Having heard the learned advocate appearing for the respective parties and upon perusal of the averments made in the application explaining, containing the explanation offered towards the absence of the learned advocate of the applicant in can 3 of 2023. When? Acha, on 15th
15/1/2000.
January 2024, comma, when the application being can 3 of 2022 was dismissed for default. Stop. কি বললাম? I am satisfied with the explanation. আমি বলেছি তো? আমি করে দিন, আচ্ছা। Accordingly, the application is allowed. Order dated 15th January 2024 is recalled. The application being can 3 of 2022 is restored to its original file and number. Thereafter, can 3 of 2022. Stop. Upon consent of the parties, this application is taken up for hearing then. Stop. Acha, having heard the learned advocate appearing for the petitioner and upon perusal of the materials on record, I am satisfied with the explanation provided towards the absence of the learned advocate. When?
My lord, 25th February 2022.
Acha, on 26th February
25th, my
2022,
lord.
when the application being can 2 of 21 was dismissed for default. Accordingly, the order dated such and such is recalled. The application being can 2 of 2022 is restored to its original file and number.
My lord, can 2 maybe listed, my lord, on
আচ্ছা, এবার
Friday, my lord.
তলায় রিট পিটিশন আপনি দেখুন, রিট পিটিশন, আচ্ছা, লিস্ট দ্য place the রিট পিটিশন in the list. When?
My lord, may I
Further consideration when?
my lord, pray for one thing, my lord. Since the 2017 matter, lordship kindly recalled, my lord, during the pandemic COVID, all the files were been destroyed, my lord. So kindly delete the petition.
Okay,
My lord,
Supply him the
and my
copy.
lord, kindly record my objections for my client, my lord. My today's appearance.
I will supply him all copies, my lord. I
Kindly,
will
my lord.
supply.
Objection to restoration.
But that for my client, my lord.
Restoration, acha. Mr. Chatterjee submits that the writ petition, that the copy of the writ petition is not readily available with him. Acha, in view thereof, acha, petitioner is directed to serve a copy of this writ petition and the application being can, the 2 of 21. Whether any affidavit was filed,
Yes, my lord. I will supply all the copies. my
acha, and all the pleadings exchanged by the parties in connection with those writ petition or application, if any, to Mr. Chatterjee.
lord.
When?
My lord, within 2 weeks.
2 weeks.
My lord, kindly
Or
consider.
within a week. Within a week from date.
Right.
Leaves the matter for further consideration 3 weeks since.
Lord.
Great, my
Under
lord.
the heading, my lord, under the heading motion, my lord.
Oh, why motion? After exchange of affidavit motion.
Under the heading here.
Huh? So there shall be no hearing matter in the High Court.
Great, my lord.
Lord.
Yes, next.
Item number 4.
Yes. 4. আবার কি করে দিন, নট টুডে লিস্টে নামিয়ে দিন, একদম পুরো থাকবে পুরো 5.
My lord, I am for the petitioner, my lord.
Hmm.
My lord, restoration application, my lord.
Within time or beyond time?
Beyond time, my lord. I have
Huh?
beyond time, my lord. I have filed another application for under. Yes, my lord. I have stated. I have served to all respondents, my lord.
So what is your stand?
কি গো, আমি তো রয়েছে অলরেডি এনগেজ।
My lord, I have stated in paragraph 11 to 14 of my section 5 application, my lord. Why I have
চুপ করে থাক না, তুই তাহলে চলে যা।
রিস্টোরটা হয়ে যাক, মূলটাতে অবজেকশন দেবেন।
অবজেকশন কিছুই তো।
ঠিক আছে।
Oh, there is a judgment, my learned friend.
My learned senior friend has no.
Always
objection.
COVID. Judgment of the division bench headed by Justice Surjokant. That the limitation period, COVID-19, the defense due to COVID-19 is available during that period, not beyond that.
Petitioner being the poor people, my lord, could not come, my lord, contact with the learned advocate.
Always COVID. Forget about the COVID now. There is a judgment. And for this court, I shall bring that judgment here. That you will be able to take benefit of the exclusion of the period of limitation during that period, 15th March 2022 to April, no,
The time of election.
when you're dismissed for default.
My lord, 9th November 2022.
Well, 28 to 2022. That period.
Lord, I have
Promoto SLP.
filed.
15th March 2022. 18th February 2022. You now satisfied whether your period of limitation expired within that period?
No.
No. Answer is no.
করবি তোরা।
So therefore,
My lord, I have
such
filed-
plea COVID-19
my
is
lord,
not available.
I have filed separate
করে দাও।
section 5 application, my lord.
নিজেদের মধ্যে
My lord,
করতে গেলে লোকে
Mr. Right, what can be done?
let it be মানে
Restore. Okay, আপনি আসুন।
Thank you, sir.
Two application equal. Can 1 of 2024 and can 2 of 2024. দুটোই একসঙ্গে নিন। আচ্ছা, having heard the learned advocate appearing for the respective parties and upon perusal of the averment made in those application, ঠিক আছে, I am satisfied. আসেনি তো?
they are engaged somebody, they did not turn up, one junior.
Oh,
That's why, my lord,
yes.
he has always assisted.
Yes. ওনার নাম দিয়ে দেবেন, পান্নালাল বন্দ্যোপাধ্যায়। হ্যাঁ? হ্যাঁ।
I don't know, 6 minutes, I'm paying for the respondent.
I am for the petitioner, my lord, affidavit of service.
স্যার করে দেবে। ফাইনাল দিন।
Within time.
No, my lord, there is delay in 385 days of delay.
Where is the application for section 5?
My lord, can 1 is for restoration and can 2 is for section 5.
Can you make order by any copy?
Yeah. How many days? Delay of how many days?
385 days.
Only.
My lord, not okay. My lord,
আচ্ছা এই সেম অর্ডার করে দিই সেম অর্ডার শুধু ইয়েগুলো চেঞ্জ হবে ওনাদের নাম আর ডাটাগুলো চেঞ্জ হবে ওকে এই এপিডেমিক সার্ভিসটা নিয়ে নেবেন
It will appear, my lord.
হ্যাঁ 3 weeks since
3 weeks.
yes
Item number 7.
my lord, I am for the petitioner.
Fine, check.
Can 1, my lord, restoration application, can 2, my lord, application for condonation of.
This is
delay for how many days
more than 5 months, my lord.
No, no, 4
5 months
Yes. This is for default date, my lord, 4th July 22, and restoration file, my lord, 9th January 2023. That I need that.
you know these tricks
My lord,
5 months is lesser digit it's
Lesser
not
digit.
whole digit
but my lord, what?
respondent when opposed will say 150 days my lord yeah 150 days and he will say 5 months only
5 months. And
5 months only
as per me, my lord, no proper explanation has been, my lord.
No, no,
Stated.
why proper?
As per my version.
Paragraph 5, my lord, I have stated.
okay
But not-
same order
Matter will appear, my lord.
3 weeks since হ্যাঁ কি দেখছি
Yeah, দেখুন ওই যে সুশোভন সেনগুপ্ত
এফডিপি সার্ভিস হ্যাভেও given
Earlier, my lord,
ও ঠিক আছে
24 April 2000.
yes
Item number 8.
eight you are appealing for the respondents হ্যাঁ
State my lord, led by Mr. Bufumul.
অ্যাপিয়ার করেছে ওনার একটা ইয়ে দিয়ে দিন আচ্ছা স্টপ ইয়ে the petitioner is unrepresented though Mr. Sachan Sir, an advocate appearing for the state respondent is present. Stop. However, to afford another opportunity to the petitioner to appear, the matter stand adjourned. List the matter for further consideration 2 weeks since. Okay, 2 weeks since.
Grateful, my lord.
Again, আমাকে তো করতে হবে।
Item number 9.
May I please your lordship, my lord? My lord, it's an application for restoration which was dismissed for default by an order dated, my lord, 6th of May 2025, my lord.
Within time.
Within time, my lord.
Oh.
Ranjan affidavit. Ranjan Shah was supposed to file an affidavit in this matter. Can you see, my lord? Pradeep Shah-
There is no delay, nothing.
Oh, no, my lord. No, I'm not on that delay, my lord. On 1st of
My lord, I'm sorry, my lord. The one that have been handed over is WPA 25520. And the petition that the senior is carrying is of 35. A different matter, my lord.
তাহলে আমাদের কোনটা?
My lord, item number 9, my lord. I am told, my lord, it
9. I mean 8, my lord. Sorry, my lord.
8 order.
Lord,
Oh, 8.
well, said,
এই ওনার নামটা লিখে দিন
8, my lord, there is a direction for filing affidavit by the my lord board, by the DPSC. In 8, my lord, lordship has a,
in writ petition.
in the writ petition.
Their matter has been dismissed for default.
Yes, my lord.
To-
That has been raised.
Today the petitioner has not come.
Oh.
I have not dismissed their application.
No.
Because they will come with another application and I am to pass the order. Okay. So I have adjourned to afford them another opportunity to appear.
Lordship.
But on the next date, it would be
But, my lord, in that matter, my lord, on 1st of July 2025, there is a direction of his lordship, my lord, to file an affidavit.
in respect of section 5.
No, in respect of the main writ petition.
Oh, So
The
at that
direction-
time, it has not been brought to the notice of that writ petition has been dismissed for default.
But my lord, two orders I find, my lord, on 30th of April, Lordship has taken up this matter.
Okay, you prepared?
I shall.
You prepared? It would be restored. And acha, Mr. Bosumol লিখেন নামটাও দিয়ে দেবেন
Get it.
ওপরে, yes. Yes. So where is the affidavit service in the
But affidavit of service is not affirmed, my lord. I'm having it ready in my hand. If your lordship grants me leave to file it by the end of by course of the day, my lord, I can do so. Served, my lord, yesterday it was served upon the learned advocate appearing for the opposite party, my lord, respondent.
So whether it would be proper.
My lord, then pass it over.
Le-
If your lordship pass it over, my lord, get it affirmed and then my lord come back.
Today, that's not meant to today. So adjourn, not today, you get it affirmed. Because if they appear, no problem. If they don't appear as a sealed, affidavit of service is required to be kept on record. Okay. Yes.
I'm grateful.
Not today, only not today.
Item number 10.
Item number 8, Mr. Saha. In item number 8, how many advocates have been engaged by the state? 3 advocates.
I have got the district private counsel.
Oh, hey, onar namta likhe din, Mr. Saha. Hey, you give your name, petitioner has not come. Oh.
He has to file the reply.
Okay. Din. Yes. Item number 10.
My lord, 10, my lord, I'm led by Mr. Shomu Mojumdar for the respondent university. My lord, he's on his legs, your lordship. My lord, I'm praying for a short passover.
But we can begin. The matter will require some time. I leave it to the court. The issue here is, the petitioners before your lordship are students of Jadavpur University. They were not alleged to have been involved in the unfortunate death of a student in the hostel who passed away and breathed his last, on falling from the balcony, the second floor. Now, these persons, the students, who are before your lordship, were intercepted by the university, and the persons who were directly behind the incident of alleged ragging are in custody even today. Trial is going. These persons, they came at a stage of show cause. Show cause post some sort of inquiry, without, however, there being any adherence to any principles. We persuaded the Honorable Single Judge to hold in our favor, whoever was hearing the matter, and hold in our favor to the extent that they are not going to proceed any further. So we have not been, the punishment is not there. Though the language of the show cause clearly, postulates that a punishment is in the offing. Whatever be the explanation to the show cause, the punishment was certain. Nature of punishment is 2 years debarment, hostel debarment, university debarment, this sort of punishments. There are different categories. Now, by way of Can 3 of 2025, one of the petitioners, petitioner number 1, has approached your lordship. He has filed his application on the 30th of June 2025. His case is after successful acquittal apart from one exam in the university engineering course. In mechanical engineering, he is perhaps a student. Mechanical and electrical. But whatever, in one of the streams, he is a student. He has sailed through in the campus recruitment. He has got a job. His final results are awaited from the end of the university. He is not going to return to the university. He has taken up a job.
The difficulty is he has one paper which he is yet to clear as a supplementary. And my lord, apart from that, his results need to be handed over so that he can give it to his employer. My lord, the entire nutshell of the entire proceedings today rests on the university vis-a-vis its stand as reflected in the various pleadings filed in connection with the writ petition. And my lord, also this application which is to be decided independent. My lord, there were endeavors at various stages which was offshooted, my lord, by way of various applications filed in connection with the writ. My lord, they suddenly decided to abruptly take certain steps. We informed the court by way of an application and that was stalled. But today the position is, your lordship is looking at a writ petition which may seem to be that there is some opportunity extended to the parties. But unfortunately, records reveal that there was no opportunity extended worth its name. You know, it's like, you know, a trial taking place where the conviction is decided. It's just a procedure contemplated by law that is being complied with. You know, opportunity of hearing presupposes effective opportunity of hearing. Well, it does not mean that anyone and everyone will conduct a perfunctory inquiry and will not nail a person, punish him. Here, from first to last, whatever documents are here, according to my humble submission, presupposes that yes, this man is guilty, punishment is in the offing, just a perfunctory inquiry is to be conducted and he is to be punished. Now, my lord, for the present, my lord, can 3 is immediately, there is some immediate urgency. My lord, I have served can 3 on my learned friend appearing for Jadavpur. What I was be respectfully submitting to your lordship, my lord, please, my lord, allow the writ petitioner to appear for the supplementary examination. And we will also direct the university to publish his results subject to the result of the writ petition. In the event, ultimately, the writ petitioners succeed, then, my lord, everything will be regularized. Alternatively, my lord, one way of looking at the problem is that. The other way, my lord, if your lordship hears the entire writ petition, my lord, on a urgent basis, my lord, I cannot have any say. My lord, I can praise the entire writ petition, my lord, I am ready to argue the petition.
So when this supplementary examination will be held?
My lord, it has already been held as my
The
lord.
final examination held in December 2020.
Para 9 of the application indicates that it has been conducted on 17th April 2025. Para 9, my lord, this is there, my lord, contention. Although, my lord, I will have to come back to proper instruction. Para 9.
Para 9, no.
And my lord, since results were not published or my lord handed over to the applicant hearing, my lord, it is, my lord, surprisingly, I don't know, my lord, how did he come to know there is already a supplementary, he needs to give a supplementary examination or there is a back, because unless the result is handed over, my lord, how can a student know? Although, my lord, I will come back with proper instruction, because, my lord, I'm led by
the result of the examination, which was held in December 2024, it has not been published as yet.
My lord, these petitioners, my lord, they have been, my lord, accused or, my lord, alleged for a very serious incident of ragging, my lord, which your lordship will know. And, my lord, they had challenged the show cause notice which was issued to them in view of the writ petition, my lord, where, my lord, arguments have been completed. My lord, now, because, my lord, there was initially an interim order to not to proceed, my lord, on the show cause notice. We had, my lord, applied so, although the interim order at the present date does not exist. My lord, be that as it may, my lord, today my instruction is, since results were not, my lord, handed over to the applicant, my lord, it is hard to presume how he will come to know about the back paper. And everything, my lord, is
And
done on the
hence-
basis of
and-
easy resolution
And hence
the
the,
seriousness of the allegations,
okay, and hence, madam, it is a specific question of the court to you,
lordship.
whether the result of the examination which was held,
Has been published.
published.
My lord.
So thereafter, petitioner came to know that he is to appear supplementary examination in one paper since he could not succeed.
My lord,
Could not succeed in that examination.
my lord,
And you
para 4,
you
my lord,
held
answers your lordship's query that the
you held
result
that
is not
supplementary examination on 17th April 2025. When you will held it again?
my lord, may I come back with specific instruction, my lord, because this, my lord, this matter is not as easy as other. My lord, there are allegations against these incumbents of serious allegation of ragging for which a student
Why,
was lost.
in that circumstances, you tell the answer, give this answer whether you contemplated a proceedings to rusticate the student.
They are final year student, my lord. The show cause notice where, my lord, for withholding one semester.
He is not the accused person of the criminal case.
Not criminal case, but my lord, he
Okay,
is
so
accused
so
of ragging.
you have not filed any FIR or anything like that. That means it is an acknowledgement of the fact that petitioner has no criminal liability.
My lord, may I come back with
Respect of
instruction?
that
My lord, my
incident
senior, my lord, has
or offense.
instruction in this matter.
So he has not criminal liability. You have acknowledged. Had there been so, you have filed one, lodged one complaint or FIR against this person also. Thereafter, you suspend, you issue show cause notice. The why and under which act you are preventing him from appearing in examination.
My lord, I shall come back with proper instruction. My lord, today I am handicapped. My lord, kindly considers, or my lord,
Even
gives it
today,
pass- kindly passes it over, my
the
lord.
inmates of the correctional home are giving opportunity to you read.
My
You
lord, he
prosecute
give
further
proper
study.
sit for the exam, my lord. He had given his exam, but my lord, only with regard
Given
to
his
supplement-
exam, but he has what I say failed in one paper. So you have to appear in supplementary examination. And now why you will not allow? Under which provision? And by virtue of which order passed by which court?
My lord, I will come back. My lord, or passes it over.
And the specific information when he is going to organize or hold the next supplementary examination. When?
Lordship, I will come back.
Okay.
May it be, my lord, subject to your lordship. Tuesday, 2 p.m. Not kindly.
2 p.m. you have
Tuesday,
your
12th.
learned fam had already booked.
Tuesday, on Tuesday. Monday, otherwise, Mr. Doctor.
No, whether you take instruction from the student concerned, whether they are going to hold the supplementary examination shortly.
So they will have to hold a special supplementary examination
Not the student,
for
Yes.
these students.
only one student.
For at the present moment for one, because kindly visualize. I have sailed through in the this process. My name figures in the portal. They have accepted money from me for appearing in the supplementary. They did not allow me to sit for the supplementary.
My lord,
They did not
17th
issue the admit card.
My lord, as is appearing from this application only, 17th April, my lord, the supplementary examination was conducted and this application has been filed on 30th June 2025. My lord, as per this application, though, my lord, I will come back with instruction.
You come back.
Stopped on my learned friend on 3rd of July.
Don't be too much diplomatic. You are not to be too much diplomatic.
My lord, I don't have specific instruction today, my lord.
My lord, the third
You
it was
just
put on.
take instruction when you are going to hold this next supplementary examination. And whether, yes, and court is not satisfied
This 3rd July.
with your explanation.
3rd July served, my lord, she was supposed to come with instructions.
Oh, yeah, that is, yeah. I think
My lord, I'm led by Mr. Shomo Mojumdar only. My lord, I was praying for a short Passover today itself. If my lord kindly keeps it after.
today this information is not available to you.
My lord, it is possibly available with Mr. Mojumdar. My lord, I.
No bench. Sorry. 1 o'clock, if it comments to you.
No.
Lordship, if my lord kindly takes it up at 1 o'clock, my lord, let
Since
Mr.
you
Mojumdar
are
come.
claiming that a special examination is to be arranged for you, at any date can be done.
Tuesday
At any
keeps
date
it.
can be done.
Tuesday keeps it.
Any day can be done.
Same position
Tuesday.
Tuesday.
What can be done? Only your learned friend are all booked that time. এই দেখুন তো একটা কাছে পিঠে দেখুন না কোন দিকটা ফাঁকা আছে একটা দিয়ে দিন।
যবে হোক করবো সোমবার আমি নেই আমি না থাকলেও
মন্ডেতে
না
আরেকটু আরেকটু পরে হ্যাঁ 31st কাম অন 31st এটা আপনি এই কোন সময় অ্যাপ্লিকেশনের হেডিং এ দিয়ে দেবেন হ্যাঁ for the learned advocate appearing for the respective parties. Oh, so I am keeping it on next Friday. That would be better. It will come under the heading application. I have decided to take up the application.
Keeps it on Friday. Keeps it on first.
Friday. But madam, you take instruction.
My lord.
Okay, you don't
It's too
deprive
overloaded, Milord.
anyone.
Doesn't find time to take instructions. আমি বলবো সৌমদাকে
My lord, my senior has instructed this matter because of the seriousness of the issue.
If you find that any person has done any criminal offense, you take action. There is a court and machinery available. If we found that any person has committed such a misconduct that he is liable to be rusticated, you have the law, bylaws, you rusticate him. But how he will, under which provision he will deprive one person?
My lord, I shall come back with instruction.
Okay.
Keep it up.
Yes.
Oh, item number 11, I appear for DVC, led by Mr. Kishore Dotto. He's on his legs, paying for an adjournment.
Problem has not been solved.
Problem has not been solved in the sense that my learned friend is claiming the leave encashment benefit of 600 days. He says he is entitled to 600 days leave encashment benefit and gratuity as per Payment of Gratuity Act. But I can show your lordship, both of these are not applicable because the affidavit, the exception to the affidavit of compliance which I have filed, your lordship kindly take that exception.
Okay, so I am fixing it for hearing what can be done. Huh?
Leave encashment has been disbursed as per the leave rules. He is entitled only 300
The
days.
personal appearance has been dispensed with. And hence the problem is not here.
They are claiming leave encashment benefit.
My lord, entire period, my lord, 50% of 33 years, 34 years service, entire period, my lord, 17 years, 50% of the service.
You tell that here court will not take any lenient view.
We have complied with
Supreme Court, have you read the Supreme Court observation and comments on your conduct and dealing with the court?
Whatever your lordship has directed, we have complied in toto, your lordship.
Okay, you satisfy on that day.
One point.
So affidavit complete.
Yes.
In respect of your affidavit of compliance. Acha. Stop. Ask quantified your service as 21 years in place of 34 years. So it is a fresh cause of action, Mr. Datta.
Moreover, leave-in
exception to the affidavits in compliance filed by the alleged contender. Yes. আচ্ছা আচ্ছা এগুলো নিয়ে নি না কন্টেম্প অ্যাপ্লিকেশন এক্ষুনি শেষ হয়ে যাবে
Item number 12.
This is my application for contempt appearing for the first time.
Yes.
The lawsuit delivered the judgment in this is Subodha censure was set aside. The lawsuit delivered a long judgment.
Oh.
That has been flouted and not complied with. I just the lawsuit judgment is that page 37 and it's just C. The relevant operative part is at 46-47.
Oh, that matter. Censure.
Censure. Set aside, it takes immediate effect. The contumacious acts I have pleaded in paragraph 11.
Whether there was any operative part?
Yes.
Furthermore,
operative part, that is page 46.
On that date, I stated to your junior that nothing you have not, your junior at the time of delivery of the judgment mentioned this matter, but you come to your payer portion, you have not paid anything. You just so that a sort of declaration from the court that the punishment of censure is bad.
Yes, because that is the culmination of the disciplinary proceeding. Censure is the culmination of the disciplinary proceeding.
Where is the writ petition? Come to
the prayer portion, Lordship.
Come to your prayer portion.
Page
to rescind, cancel, and withdraw.
The charge.
Memorandum of charge sheet and order of such and such.
Yes.
Then certiorari. Then
Certiorari,
prohibiting them from giving effect.
Yes.
And from giving effect. Now you say, where is your mandatory? Whether you paid for any mandamus? You come to your prayer portion.
Here, but the prayer.
Mandamus. Actually, you paid for certiorari and prohibition.
No, mandamus for setting aside or quashing.
And the court has quashed.
Yes.
Court has quashed.
The effect.
Court has quashed.
Of the judgment is that there is no disciplinary proceeding pending against him, as if no disciplinary proceeding was ever held against him, because the censure is the culmination. Kindly consider this. I have pleaded in paragraph.
You have not made any specific prayer, and hence there is no. I at that time, I consider your junior. You have not made any specific prayer. Mandamus.
So I was there when the judgment was delivered. Judgment was delivered. I think I was also there. Now the result is
you find paragraph number.
Kindly have a look to
paragraph number 2021. There is no specific direction. There are no specific direction. Only the punishment of censure was set aside.
Yes, and quashed.
And quashed.
Yes.
And appellate authorities order also quashed.
Yes.
Only that portion.
As well as the reviewing authorities order, that was
quashed.
Yes.
But thereafter, you have not paid any.
It is
better you file a writ petition if you find any impediment.
No. I just want to assist your lordship. Kindly have a look to my contempt petition once. Page 46 of the contempt petition. Kindly have a look.
Oh, contempt petition, I'm coming later on. You come to page paragraph 20 and 21. It is the actually operative part of the order, violation of which is complaint of.
Paragraph 20 of the order, judgment.
Yes, it is the operative part.
Yes. That's what I was placing. Page 46. Therefore, based on the foregoing discussion, the only conclusion that can be drawn is that the punishment of censure is unsustainable and cannot be allowed to stand. Accordingly, the portion of the order passed by the appellate authority imposing the punishment of censure upon the petitioner is hereby set aside. Consequently, the order passed on the revision petition, if any, insofar as it affirms the said punishment, is also liable to be set aside and cannot be sustained. Then, as previously noted, the petitioner seeks a direction restraining the respondents from giving effect to the charge sheet, inquiry report, the final order of the punishment, and the order of the appellate authority. However, in view of the doctrine of merger, it must be held that the final order of punishment has merged with the order of the appellate authority and no longer stands independently. Furthermore, the charge sheet and the inquiry report merely represent preliminary findings or allegations that indicate a prima facie, the validity of which is contingent upon acceptance by the disciplinary authority. Therefore, in the present context, passing any order concerning the charge sheet or the inquiry report would serve no practical purpose and would therefore be odious. Now,
So therefore there is no mandatory direction.
Worship, kindly consider, I have not.
Now you can hear
I have not
that
come with the
everything.
judgment. There is a judgment. It's not required. If the mandamus is issued quashing the impugned order, it naturally follows. It is a natural corollary that it takes immediate effect. Here the censure is the culmination, I repeat, is the disciplinary proceeding. Now, when censure
Mandamus, therefore, it is a declaration that means appropriate direction, appropriate order, and it is a certiorari to set aside those documents. There is no mandatory direction upon
I
the
remember,
respondent.
I won one case before Justice Manoj Mukherjee sitting in court number 13. Possibly it was in early 80s. Now, one dismissal order was set aside. I prayed for consequential directions. Court said, I remember distinctly, subject to correction, I'll bring that judgment. That is not necessary. When the dismissal order is set aside, it gives you everything. Court is not required to pass any consequential direction. It's not required. That's what I have pleaded in paragraph 20 of the contemplation. Kindly have a look. What I have said in paragraph 40.
I accept that proposition that if the final order of punishment and appellate authority's order or the reviewing authority order is set aside, the authority is required to give all the benefits. Court just said set aside. Court hold that it is held that it is bad and set aside. But court did not direct him, give any direction that you give any service benefits or such and such.
In my humble submission.
Now their failure to give service benefit despite their order of punishment being set aside by a court of law would give a fresh cause of action. Whether contempt proceedings lies.
It will lie.
Okay.
I'll bring.
I am really at the time of hearing you have to face this question.
Yes, ignoring ignoring is a court or ignoring or disobeying.
Okay, I mean,
is a contempt.
this present contempt application has been preferred alleging willful violation of the should prefer the memorandum of review. Petitioners could. Petitioners should prefer the memorandum of appeal, review.
I think Malad, they are the same. They are the same persons.
Should be same person. Third party can also file a review application.
Yes. If
Any
he-
person
if
order for twist. Yes.
returnable is
47 rule 1, the any person includes third party also.
yes, and can favor appeal also.
Yes.
71
Seeking-
Supreme Court.
Seeking leave.
Yes,
Seeking leave from the court.
1971 Supreme Court.
Yes.
The returnable date is
Order.
তাদের হবে
To the petitioners who filed the paper, the memorandum of review.
only one prayer. Malad, today we are on 25th.
Another week time.
Because if it is returnable on 1st of August, it's
Hey, first of all, sorry, না, তাহলে
very difficult to serve.
তাহলে 22nd August. 22nd August. Second.
Time will be very short.
22nd. Yes.
Also, great.
Next.
I satisfy your lordship about the consequences if no directions is given. I'll satisfy.
No specific direction, Mr. Doctor.
But I'll satisfy.
That yeah.
Item number 13.
but there is charges.
মনে করলেই আছে
At that time, এটা বন্ধ করুন না। এটা বন্ধ করুন তো।
But item number 13.
Item number
For the petition.
Item number 13, my lord.
Its order
Lord,
is,
may I just-
my lord,
My learned senior is
49
appearing for the petitioner, my lord.
এক সেকেন্ড ভাই একসাথে বলে নি তারপর আপনারটা আপনি বলুন
আমি বলে দিচ্ছি। My lord, my lord, there was a my lord, direction, my lord, passed by your lordship, my lord. I believe, my lord, today it is appearing for the first time, my lord. I am just
Yes.
seeking your lordship's kind direction, my lord, to serve a copy of the application upon us because we are appearing for the southern, southeastern railway.
Direction was at page 56, kindly see.
Okay, yeah. That academic part, you want one seniority list.
Yes, well, only thing to publish the panel. Only thing to publish the panel. How they are afraid of that, I don't know. Why they are not publishing the panel. However, they have not complied with till date. They have not complied with your lordship's order. We have communicated your lordship's
Actually, Mr. Chakraborty, this court has not stated anything new.
Yeah.
The division bench was said,
My lord,
this court also said
my lord,
so.
my lord, I'll not, my lord, take your lordship to the merits of the case right now because your lordship is disposed of.
Yeah,
My lord, my lord, one
I'll
thing,
have a
one
copy.
thing. My lord, one thing, my lord, I must point out, my lord, we have, my lord, filed MAT, my lord, 1053, my lord, challenging your lordship's order. My lord, if your lordship kindly records that, my lord, that is pending, my lord. I'll just seek, my lord, much time, my lord, just to, my lord, dispose of, my lord, at least the first move, my lord.
Have you filed any
Before that-
application, sir? Any application is filed?
My lord, I'll just tell your lordship, my lord, MAT 1053 of 2025, your lordship kindly adjourns the matter, my lord, for a considerable time, my lord, so that I can move, my lord, my appeal.
Oh, okay. This contempt application has been prepared alleging willful violation of the order. of expeditiously, don't worry.
For our purpose, date may carry.
No, not in this matter, in other matter. Okay. Next.
So after 6, suitable after 6.
6 weeks. 6 weeks. Hey, 6 weeks করে দিই। Yes, 14.
14 months after the petitioner, pursuant to lordship direction, I have served a
My lord, he has joined.
Order complied with.
after serving the contempt application.
Join.
Oh,
Consequently,
what is this?
After serving of the contempt application, they have my lord allowed to join.
Acha, stop. Yeah.
See affidavit of service.
Acha. Affidavit of service filed by the petitioner is taken on record.
Item number 15.
15 I appear for the petitioner, my lord.
Yes.
My lord, your lordship was pleased to my lord dispose of the writ petition on my lord 7th of May, my lord. Now, my
Not
lord,
complied with.
not complied with.
Communicated.
Communicated.
আচ্ছা এই ওইটা লিখে দিন ইয়ে বাবু
My lord,
give notice
yes, my lord.
give notice এই অলোক বাবু
First notice was sent on
লিখে দিন ওটা
29th May.
Yeah.
Thereafter, my lord,
alleging violation of the order হ্যাঁ
my lord, they can explain, my lord. First
it is a 3 weeks time is given a last chance to them to comply with the order. Okay, that if you don't comply, now the court will now proceed. Yes, next. Huh? 12 PM matter. Yes. Oh,
Item number 29. 37.
okay. I have one. Which matter?
In this matter, Mr. Bhaskar Prasad Banerjee is appearing for the respondents. My lord, he, due to his personal difficulty, this rain and water lock today could not have come to court, my lord. Only not today, nothing else, my lord. I'm praying for only not today. Monday, it can be fixed anytime, subject to my learned senior.
My lord, whichever dates, my lord, I cannot.
Shall I fix it to 2 PM on that date available? It would be 25 last week of August.
Your lordship is going away, my lord. Your lordship is will not be available.
No, not available.
So, my lord, kindly.
Your learned friend has already booked 2 PM. 1 2 p.m. matter, 2 p.m. matter.
Kindly keep us at 12:30, my lord, 12:30 any day.
12:30, did matter whether concluded 12:30.
1 hour I need, my lord. 1 hour.
1 hour you need.
Within 1 hour I will conclude.
এই একটা 2 p.m. একটা ফাঁকা দেখুন না, ফার্স্ট 2 p.m. matter.
Instead of fast, my lord.
No, so that you can get fast 2 p.m. matter.
Yes, my lord. Yes.
22nd August I can give fast 2 p.m. matter at 2 p.m.
We'll do that.
Acha, had the learned advocate appearing for whether any order is required to be passed. Okay. So কিন্তু এটা টাইমটা দেওয়া থাকলে আপনি দেবেন তো নাকি না অর্ডার করে দেবো আপনার জন্য অর্ডার করে দিলে ভালো হয় আচ্ছা ঠিক আছে হাত দালানে
I'm appearing for the plaintiff opposite.
ও আসেনি থাক 38 Oh, where is Mr. Chakrabarty?
কোন মামলা 38 15 16
Your learned friend has not come. 1 minute. Your learned friend has not come. Okay, pass over, let him come. Okay, not today.
He will come, my lord.
Today from 2 p.m. and onwards, I am to sit in the division bench.
সুপ্রিয়দা
Okay, what's the problem? Yes. So I'm proceeding with the rest matter? Yes. So what's the problem, Mr. Bhattacharya?
I'm appearing for the caveator opposite party.
what happened, my lord? Now, my lord, here, my lord, the defendant number 3, my lord, is the petitioner before your lordship. Now, my lord, here, what happened, my lord, we filed an appeal, miscellaneous appeal.
1 minute. What is the impugned order?
22nd August 2024.
23rd July 2024.
That is, my lord, the learned trial court's order.
Learned trial court's order. Appeal court's order is at 22nd August and, my lord, the 3rd September.
July 2024. It is an application. First, status quo. So direction has been given to maintain status quo.
Status quo.
And then 20 August, this is a miss appeal.
Challenge filed by the defendant.
Appeal be admitted. So challenging the interim order, one miss appeal has been preferred.
Now, my lord, connection with that, my lord, I filed an application for stay. My lord, that has been rejected by the, my lord, impugned order.
What? Stay of the order whereby you are directed to maintain status quo. That means you want to change the nature and character during the pendency of the suit proceedings.
My lord, two things, my lord. My lord, when the court is granting an ex parte ad interim order of injunction, my lord, court has to look it prima facie, give a finding whether the suit is at all maintainable at the stage. My lord, that is, my lord, our primary point. My lord, suit is, my lord, on the face of it is not maintainable. Whether court could have at all passed an ex parte ad interim order of injunction. One, that will be my primary. My lord, kindly see, my lord, what are the averments made, and then I shall be showing your lordship the West Bengal Municipal Act. The suit is otherwise not maintainable. Whether court could have at all, my lord, passed the order of injunction. Kindly see, my lord, the plaint, my lord, which is
What is the suit for?
My lord, this, that is the plaint. Kindly see the at page, my lord, annexure A, para 13.
Yes.
Page 13.
Prayer portion, prayer portion.
The prayer portion, my lord, starts from page 23. How many reliefs have been claimed? Page 23.
Yes. Degree of declaration that the construction made by the below is illegal and unauthorized one.
Yes. Decree for declaration that the plaintiff, the declaration that the defendant number 1 to 3C have no legal right to make construction over cost schedule property. Decree for declaration and permanent and indefeasible right of enjoying air and light throughout the suit property described in Kha 1 schedule below for enjoyment thereof by the plaintiff and the members of her family. And then, my lord, 4. A decree for declaration that the new Pakka construction of multi-storied building of so constructed in Kha 1 schedule property situated in the southeastern part of the property in Kha schedule property below are illegal and unauthorized one. These are the declaration. Then, my lord, next, a declare that the illegal and unauthorized construction of the Kha schedule the property have
yes, so suit for declaration. And allied pair. Now you show the municipal act that
before certain prayer
that any statute has ousted the jurisdiction of the court.
Exactly. Kindly comes to Milord, kindly comes to Milord the prayers, the paragraphs in the plaint. Why I say so?
No, you show that.
That is what I am showing to your lordship. Paragraph, Milord, kindly comes from page 15, para 3.
Yes, para 3.
Yes. That the defendant number 1, 2, and 3 are the adjoining landowners of the piece and parcel of Vastu land measuring about 5 katas more.
Yes, court has understood that they are the adjoining landowner.
Yes.
And hence they are claiming that their right to enjoy the free air and light is being hampered.
Then Milord kindly comes to Milord para 5 and 6. That the defendant number 3 being the partnership firm and being the developer of the cost schedule property represented by its partners, the defendant number 3A, B, and 3C demolished the 2 old stories building standing on the over the cost schedule property herein below mentioned and stated and started to make new multi-story construction over the cost schedule property herein above.
Yes.
The said building, well, at 6 is very important. The said new construction of the multi-story building, the above stated developer named the defendant number 3 represented by its partners, the defendant number 3A, B, and C erected Pakka masonry structure up to G+3 floor level of the cost schedule property herein below without keeping requisite side open space in the southern, eastern, and western side of cost schedule property herein below mentioned. It is also to be mentioned that defendant number 3 represented by its partners, the defendant number 3A, B, and C had been making the said construction without keeping any requisite side space in the southern side of the cost schedule property here below mentioned. Moreover, the defendant number 3 represented by its partners, the defendant number 3ABC has made unauthorized construction of the width of the 3 feet in north south in length of 78.3 east face in the extreme south portion of the G+3 level over cost schedule property herein, which is specifically described in the Kha 1 schedule property. Therefore, Kha 1 schedule property, Milord, is the unauthorized part according to them. By throwing dust in the eyes and rules of the construction of the new masonry structure under the West Bengal Municipal Act 1993, and the rules framed there. Not only the defendant number 3 represented by its partners, the defendant number 3, A, B, and C constructed the multi-storied building through its pillars, columns, and thereafter the said new pillars, columns were put down from the first floor. by the defendant number 3 and
Okay, it is, Mr.
defendant number 3 A, B, and C, for which, my lord, it is.
Okay, it is the details of
I
their
may be permitted to
grievances.
place my case, my lord. I may be permitted. The apprehended that the multi-storied building would near future be collapsed, for which the life and property of the plaintiff, my lord, are in danger. Then, my lord, paragraph 7. This is where I am harping on. That this is the plaintiff lodged a complaint on 5th June 2023 before the defendant number 4. Defendant number 4 is the municipality. And which the office of the defendant number 4, after putting its seal and signature on receiving section, put the copy thereof and the inquiry from the cost schedule property herein mentioned by the office of the defendant number 4. The defendant number 4 issued show cause notice to a defendant number 1. Therefore, municipality took cognizance of the same by memo number such and such dated 7 June 2023 in a manner in that manner. It is hereby informed that as per inquiry of the above mentioned holding, it has been found that you are constructing a multi-storied building on the above mentioned holding by deviating from the plan which is duly sanctioned from from this office, which is in violation of the West Bengal Municipal Rules 2007. You have to show cause as to why the building shall not be demolished. There was show cause issued. Then, Miller, kindly see para 8. Is that in spite of receiving the show cause notice dated such and such, defendant number 1 is carrying on, Miller, the illegal and unauthorized construction. There was GD was lodged. Miller, these are the Miller pleadings. Then, Miller, kindly see Miller section 407 of the Miller of the West Bengal Municipal.
Yes.
Here, Miller, municipality is a party. Kindly see, no suit shall be instituted in any court having jurisdiction against any municipal authority or any other employee of the municipality or any person acting under the direction of any municipal authority or any office or other employee of the municipality in respect of any act done or purported to have been done under this act or rules or regulation made therein until after expiration of 1 month of notice in writing has been delivered or left at the office of the authority or at the office of the residence of such officer or such and such. If the municipal authority or the authority or at the office of which the officer or employee, but that is not relevant. Therefore, my lord, no suit shall be instituted without notice. This is, my lord, akin to section 80 of the Civil Procedure Code. There, my lord, 90 days. Here, my lord, 30 days notice. Now, my lord, municipality is a direct party, is not a pro forma. Therefore, issuance of notice, and it says no suit shall be instituted in the court having jurisdiction against any municipal authority or any other employee or a municipality or any person acting under the direction of municipality or officer of the in respect of any act done. Here, my lord, act has been done. They allege unauthorized construction. Municipality issued show cause. Municipality, my lord, issued a show cause asking me why it should not be demolished. Why it should not be demolished. Yes. Kind enough to see 407.
Yes.
Therefore, my lord, when my lord, municipality has taken steps and municipality is a party, my lord, respectful submission is without giving a notice under section 407, the suit could not have been initiated. If the suit is prima facie not maintainable, my lord, injunction could not have been granted.
Okay. Yes. Whether it ad interim order?
Ad interim order without affidavit. Injunction application is pending, my lord.
Yes.
Lordship, may kindly have a look to, my lord, the order dated 23rd of July, my lord, first. Because, my lord, everything, my lord, starts from there and my learned friend, my lord, has submitted. Lordship kindly sees Lord, the third paragraph from the top. It is submitted that it is from the ad interim order of injunction. Lordship kindly sees. The defendant in their written objection. Written objection was filed. It is a contested one. Injunction allowed upon contest.
Contested?
Yes. Lordship kindly sees. What? No. Lordship kindly sees, my lord, the order. The temporary injunction is considered and
Order
allowed.
first page is not here.
Lordship kindly see, I have the first page. No, I do not know why the first page is not here.
First page is not here.
First page nahi rehta. Lordship kindly see, my lord. Lordship kindly excuse me. This is my lord underlining. Upon written objection, consideration of all documents, series of documents, my lord.
Injunction is considered allowed.
Temporary injunction.
This is not ad interim, my lord. How my learned friend?
Not very well.
Very well. My lord, he all along, my lord, his submission is based on ad interim order of injunction, my lord, challenging that my learned.
So after hearing the municipal authority as well as
yes, it is a contested one. Now, my lord, my issue, my lord, starts from here. Now, lordship kindly sees their stay application for once. My lord, much has been argued, my lord. 407 and all this. Lordship kindly sees their application for a moment.
What?
My lord, their application for stay, my lord, filed before the appellate court.
Page.
My lord, page. My lord, page 54. Lordship kindly sees. Only 3 paragraphs.
Yes.
Nothing has been, my lord, mentioned. Why, my lord? He is, my lord, praying for stay of, my lord, operation of the order of injunction. Nothing. Now, lordship kindly comes back to, my lord, their written objection filed before the learned court below. My lord, page 39. My lord, this section 407, my lord, be that as it may, I will, my lord, come to that also. My lord, section 407 point, whether taken, my lord, lordship kindly sees the. Your lordship kindly peruse. Yes, definitely, I have point to argue. My lord, lordship kindly sees their written objection. My lord, nothing is there, my lord, with regard to the point of maintainability and 407. Nothing. My lord, upon contested hearing, my lord, upon perusal of all documents, my lord, this order was passed. This, my lord, order of status quo was passed, my lord, upon contested hearing. My lord, nowhere, my lord, it is mentioned that this is not maintainable because of 407 is a statutory bar and all this. My lord, I'll come to that bar also. My lord, it is not applicable to here also. Now, lordship kindly considers the order, my lord. 2 orders have been assailed by in a single writ petition. Although, my lord, I am not too technical. I am not, my lord, taking that, my lord. Lordship kindly sees, my lord, the first order, 22nd of August, my lord, 2024's order. This is the first date order, my lord. He has challenged 22nd of August, 2024's order. First day of, my lord, the appeal.
Yes.
When, my lord, I didn't appear, my lord. Lordship kindly sees, my lord, he is praying for ex parte ad interim stay of an order, my lord, which has passed on contest. My lord, there is a clear bar, my lord, I can rely, my lord, these are well settled judgment. I have not come, my lord, with that. I didn't think, my lord, it will be argued. My lord, starting from, my lord, Gautam Hada's case, my lord, ex parte, my lord, stay of, my lord, an order of injunction which has been passed on contest is not maintainable at all. This is not maintainable at all. My lord, they have prayed. Lordship kindly sees how the learned judge has, my lord, dealt with. My lord, lordship kindly sees, put up, moved, and my lord, it was, my lord, kept for disposal. Lordship kindly sees, record is transferred to ADJ. The first order, my lord, is nothing is here, my lord, to challenge. My lord, so far as I have understood. Now, lordship kindly see the second order. My lord, second order is order number 3, my lord, dated 3rd of September. My lord, praying for stay of operation of that order, my lord, that to my lord in my absence. My lord, kept, my lord, 7th of October 2024 for appearance. My lord, my humble submission is, my lord, where is the harm, my lord, committed by the learned court below? My lord, where?
Date has already gone. 10 September 2024.
Yes, October. Now it is being contested, my lord, so far as, my lord, I have to take
Whether
instruction.
appeal is still pending.
Pending or not, my lord, I have to take, my lord, instruction. That instruction I do not have. But lordship kindly sees,
Yes, yes, yes.
Now, Lordship kindly sees, my lord, the ex parte order of stay, my lord, is not maintainable in my absence when, my lord, the injunction order was passed on contest and disposed of.
So,
My lord, this is, my lord, I can, my lord, this is a well settled law, my lord,
Yes,
right
yes,
from, my lord,
yes,
96 ILR, my lord, Gautam Adas case, my lord.
Gautam-
Thereafter, this division bench judgment, my lord, Mr. Shubhra Kamal Mukherjee, then, my lord, Mr. Tandon.
But the Justice Tandon's division bench, my lord, has distinguished that.
Distinguished,
I have,
yes,
my lord,
yes, my lord,
that also.
mere distinguished, my lord, will not do.
No,
My
it
lord,
has
on
said
what
that
point it has been distinguished?
It's not a good law.
My lord, the distinguished, my lord, point is, so far as, my lord, any fraud is committed, then, my lord, court has power to, my lord, or, my lord, the court lacks jurisdiction. There, my lord, court has power to, my lord, grant, my lord, ex parte stay, my lord, of the contested order. That is the only distinction made.
Oh.
It is not a case of fraud. It is not a case of, my lord, quorum non juris. Nothing.
Suit is otherwise
My lord,
not
they are one at a time. My lord, there, my lord, the point taken, my lord, only with regard to 407. Now, Lordship kindly comes back, my lord, to 407 for a moment.
Yes. No suit without without giving 1 month notice.
Yes, my lord, that is
4071.
yes, that is with regard to, my lord. Lordship kindly sees the language stars. No suit shall be instituted in any court having jurisdiction against any municipal authority. My lord, my humble submission, this is not a simplicity suit against municipal authority. My humble submission, this is a suit against the private party. My lord, going on making construction, my lord, this, my lord, particular bar will not take away my right to, my lord, seek a declaration under section 9. My lord, civil court's jurisdiction is there, my lord. Declaratory power, my lord, no court has, my lord, save and except, my lord, the civil court. My lord, the declaration power, my lord, this power is, my lord, vested only, my lord, to protect the municipal authority so that, my lord, they are not injuncted or they are, my lord, not injuncted ex parte rather, without any notice. This is the purpose of, my lord, the, my lord, even, my lord, in this suit, my lord, had I been, my lord, my lord, make a prayer, my lord, with regard to, my lord, injuncting, my lord, the municipal authority, my lord, I could not have, my lord, moved the injunction application, my lord, without, my lord, granting them an opportunity by way of, my lord, notice. Notice is prerequisite here. My lord, that is, my lord, the purpose of bar. My lord, section 9, my lord, will not, my lord, be overridden, my lord, by this, my lord, 407 provision. My lord, suit is, my lord, completely, my lord, the remedy is available under section 9. Declaration, so far as declaratory relief is concerned. Now, Lordship kindly considers this. My lord, the nature of, my lord, the order passed, my lord, in 23rd of July is only, my lord, status quo. My lord, what is the purpose of vacating? My lord, rightly, my lord, fall from your lordship, my lord, initially, my lord, that, my lord, the purpose is to nature, my lord, the change and character, my lord. Changing the character of the, my lord, suit property. My lord, once it is changed, my lord, it is irreversible. My lord, I cannot, my lord, put back, my lord, to the same status, my lord, as it is, my lord, called status quo ante. My lord, if this status quo order is not there. Lordship kindly sees, my lord, the court, my lord, learned judge in the court below has taken consideration of all the documents submitted by the defendants. And, my lord, all, my lord, averments made in the written objection. It is a complete, my lord, recent order, which my learned friend's client is, my lord, seeking ex parte ad interim stay, which is not at all permissible. My lord, if your lordship so desires, my lord, I can, my lord, give those judgments, my lord.
Lord, a very short reply. Kindly comes to me, Lord, the relief sought for in the plaint, paragraph 23.
Yes.
Kindly see a decree 4.
Page
23, my lord, 23.
23, yes. Yes, yes, yes.
4, Roman 4. A decree for declaring the new Pakka construction of municipal buildings was sanctioned in the Khashidul property situated in the southern portion of the property is described in Khashidul below are illegal, unauthorized, and same are in willful disobedience and contravention to the building rules and West Bengal Municipal Act 1993 as amended by the West Bengal Amendment Act 1994 and the rules they are under. Therefore, they are taking recourse under the West Bengal Municipal Act. They want to show, according to the building rules, it is not maintainable. And municipality has given a show cause. That's why, my lord, the language in 407 is any act done by any officer of the municipality. 1. Number 2, kindly see, my lord, 8. 8. Prayer 8. Prayer 8 at page 24.
Yes. Yes.
Kindly see a decree declaring that the building plan, if so sanctioned by the defendant number 4 and 5. Who are 4 and 5? Municipality and chair, board of councillors. In favor of defendant number 1 and 2, that is my client. In the cause schedule property herein are illegal, ultra vires and unenforceable, and in defendant number 1, 2 are not legally entitled to erect a structure or many machinery construction of the same. Therefore, he is also challenging, my lord, act done, purported act done by the municipality. He wants to get the plan sanctioned by the municipality cancelled in this suit. 1. Number 2.
Municipality, whether in their written statement or objection raised this point.
I don't think they have at all appeared.
So if notice is not given to the municipality, who will be agree?
But maintainability, no, anybody can argue that. Anybody can argue.
What is the purpose of giving 1 month notice or 2 month notice, section 80 notice to the office or to the state?
I have a cause of action against state.
No. So that the state is a body should be given reasonable opportunity to prepare itself to defend the same.
Here, my lord.
So if any notice is not given to a body, CPC in compliance with the section 60, the body will be most sufferer, most affected, since the time specified by the legislature has not been given to him to get itself prepared.
So then, my lord, any act done by the municipality.
But the person, the plaintiff, the private individual, is ventilating these grievances. The notice which was required to be given, 2 months notice or 1 month notice, that has not been given, and hence suit is declared. But municipality is not raising this issue.
No, I don't think, my lord, maintainability.
Rather, the municipality, according to you, municipality has prima facie found that there was a violation of the.
Thereafter, municipality will take under section 218.
Whatever municipality will take, it is their.
Therefore, this prayer is not before a civil court.
Okay, I have got the point. Yes, Asun. The present application under 227. Yes. Under 227 of the Constitution of India has been prepared. Challenging the legality and propriety of the order dated 3rd September 2025, whereby the learned additional district judge first track court Srirampur refused to entertain the petitioner prayer, entertain to defendant stroke respondent stroke petitioner's prayer, bracket hereafter referred to the petitioner. Petitioner prayer for ex parte order of stay of the interim order passed by the learned trial court, directing the parties to the suit to maintain status quo as regards the nature, character, and possession of the suit property. Stop. Secondly stated, the facts leading to presentation of this application is that the plaintiff stroke plaintiff, namely Srimati Konika Das Burman, filed a suit for declaration and other allied reliefs before the court of institute a suit করবেন institute a
junior division first
before
court
the court of civil judge junior division first court Srirampur, which was registered as title suit number 564 of 2024. Stop. Along with the plaintiff
My lord,
That
kindly, my lord.
since the court has got no idea regarding the condition of the docket of
My lord, in this case, because kindly see, my lord, I am the, my lord, what sufferer, I am the developer.
I know,
My lord, I'm
but
the what sufferer.
at this stage you consider that permission to change the nature of character.
No, no,
or
I
further,
time
it
frame.
would be. If the I am saying, if the generally court will not give, if in the meantime nature and character is changed, then one mandatory injunction order pair will come.
The procedure proceeding.
One amendment application will come.
No,
Then
the prayers are
regarding that,
already there.
no, if in the change they will say the direct mandatory injunction to demolish.
Already, that prayer is
No,
there.
but the amend, my lord, further.
Mandatory injunction is
Will
there.
not the amend further?
Further, suppose he has made a further additional construction or further construction, then again mandatory injunction. Regarding that application, up to Supreme Court, go. Actually, the issue raised by the issue is whether you have violated the municipal rules, violating in contravention of the violation of municipal rule, you constructed the building or not. Let it examine.
Yes, my lord, kindly let a time frame be given, my lord. Kindly, my lord. That is the only request.
Preferably within a period of 6 months from the date of receipt of a copy of this order.
Yes,
My lord, even my lord, it is fixed for SR and AD. SR AD not completed, my lord.
Yes, you appear. You are the.
I am not the only party. I have already, my lord.
He is the.
SR AD, my lord, not completed.
Let him appear. He is the my lord, plaintiff.
Already appeared.
He will only contest.
No.
Other
parties are here.
From
Other
the
parties are
date
here.
of receipt of service of returns by the learned appellant.
Lordship.
Learned court.
Here, my lord. This is regarding that criminal revision. Your lordship was pleased to restore, my lord. That filed a bail application, my lord. The petitioner is in custody for more than 6 months. Lordship, my learned friend is here.
Which provision?
11 of the IPC
411.
for 2 years.
Which property you purchased?
According to them, my lord, they allege that the transformer coil has been stolen.
Coil. Habitual. Habitual.
There is no such allegation.
এটা বন্ধ করুন তো এটা বন্ধ করুন তো
My learned friend is here, my lord.
এই yes. Are you this already expired, not still
Expired on 30th.
expired? So extension, not it would be reinstatement. So you okay on that date, on the next date it would be.
20, my lord, kindly.
Now you have come. I don't have a date. সাড়ে দশটা ওরকম একটা দিয়ে দিন না।
My lord, Wednesday I will have some difficulty, my lord. My lord, kindly give a date in the month of September, my lord. Well, I am appearing in this matter, my lord, for the my lord, the mentioning which is going on.
No, not to have not so urgent matter and so important matter that this matter is to give preference over the all other matter. One headmaster has got. Now he will get 6 lakhs and certain, and if he succeeded, then they get revised pension. Okay, he is getting some pension, but according to lesser.
No, my lord, lordship, one thing, my lord, as it was mentioned.
থার্টি এমন জায়গায় দিয়ে দেবেন যাতে ওটা করা যায়।
Lordship, item number 20, my lord.
As I had mentioned,
only thing is that the file has come, my learned friend is appearing, Mr. Chakraborty is appearing opposite party. Well, it will take 10 minutes time, very short.
Writ petition or
Writ petition. Writ petition.
hearing?
Yes, only for order. Everything is complete.
I have not heard.
Your lordship will hear it out and then your lordship will pass. Everything is very clear. The respondent.
Under the heading for orders. Or upgraded matter in Mathai di Dinota. Upgraded matter. When upgraded matter will be taken up, your matter will be.
1,600.
I mention. He mentioned this matter on several occasions.
Lordship, item number.
Who is your other side?
But this matter probably affidavits are not complete, Lord.
Because
Because I have,
because the respondent they
Lord, I just seek Lord time, Lord, for filing affidavit because this requires affidavit.
So one order extension of
Here, Lord,
time.
let it appear. I'll seek Lord direction from your lordship, Lord, to.
And hence, Mr. Panda, I am making request. Please include the ready for hearing matter, which can be.
I'm supplying the copy. Supplying the ballot number.
Okay, let it. Yeah.
Appear, Lord, I'll seek direction
Lordship,
for affidavit, Lord.
Lordship, item number 20, my lord.
ঢুকিয়ে দিন একটা upgraded hearing matter আছে না ওইখানে ঢুকিয়ে দিন।
Lordship, item number 20, as I had mentioned, my lord, very short matter. Only bail application has been filed. That has to be moved.
একটা দিনে দিয়ে দেবেন তো সামনের সপ্তাহে
Monday, my lord. Kindly keep it on Monday. If your lordship.
Actually, I have thought, I have not indicated in my list that on Friday I shall take contempt application, criminal matter, assigned matter on Friday.
Lordship, it will take just 2 minutes. My learned friend is here, my lord.
Wait till Friday, next Friday.
My
It would be
learned
next
friend is
Friday.
here,
Your
he's in
matter.
custody, my lord. Petitioner is in custody. My learned friend is here. It will just take 2 minutes of your lordship. Kindly consider.
2 minutes rejection.
My lord,
within 2 minutes I can reject also.
lordship, kindly consider very small matter, my lord.
Taking risk.
Revision is pending. In
Within
that
2
revision, my
minutes
lord,
I
bail
can allow your pair. I can reject your pair.
My lord, restoration was allowed. My lord, subsequent to that, this particular bail application has been filed. Very small matter.
একটা কোন দিন ফাঁকা আছে একটা দিয়ে দেবেন which matter
That bail matter, my lord, item number 20, my lord, Dalim Sheikh.
Oh,
your lordship can take it up right now, my lord, if your lordship.
Right now.
My lord, kindly.
I am to sit at
My lord,
2.
I am so sorry.
I am to leave them.
Lordship 25, your lordship.
They are also since the
Kindly
morning
take it
they
up
are working.
on Monday, if your lordship kindly.
একটা দেখে দিয়ে দেবেন মঙ্গলবার হবে মঙ্গলের দিকে দিয়ে দেবেন। So we are 29th. Let's see whether he is entitled to get bail or not. Okay.
Well, kindly keep it at the top of the list, madam.
Lordship could extend it.
It is not a time to mention, madam.
Lordship till September, any date on Friday can be.
Okay, it will remain on Friday. When it will taken, you discuss difficulty you are facing. Okay, on that day, next Friday.
Grateful, your lordship.